Hello, everyone. This is Tom Fox. I'd like to welcome you to episode 193 of the FCPA Compliance and Ethics Report. Today we have a special Labor Day weekend edition. It is around the court's lifting of the suspension of Tom Brady by the NFL over Deflategate. I'm back with well-known New England Patriots homer and Uber fan Jay Rosen. We break down the court's ruling. I take a look at it from the legal perspective. Jay takes a look at it from the Uber fan and New England Patriot homer perspective. And then we take a look at some of the lessons learned from the compliance perspective. It's a fascinating ruling. Lots of good stuff in there for the compliance perspective, and we break it down for you. The episode comes in at just over 21 minutes. I think this will be a very good one and fun one for you to enjoy over your Labor Day weekend. Thank you very much. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report with Jay Rosen. And yes, you knew it was coming. Our analysis of Judge Berman's throwing out of the suspension of Tom Brady over Deflategate. So, Jay, we've been drooling and chomping at the bits to go at this one, so are you ready?
I'm doing my touchdown dance and ready to go.
So, for those of you who haven't touched in on one of our podcasts before, Jay is the ultimate New England Patriots Uber fan and homer. So I've asked him to talk about the judge's ruling really from the fans' perspective. I'm going to take a little bit more of a legal analysis, and then we're going to try to tie it together with some compliance points. So, Jay, as the well-known homer that you are for all things New England, what did you see in the judge's ruling that really jumped out at you?
Well, first of all, I have to say that this could not have come as a better time, especially with the season that the Red Sox have had. So this is a well-welcomed ruling in New England. Our point of view is skewed, and especially, from the Patriots' perspective, they love to have this kind of stuff, to have a chip on their shoulders. So, I don't think Tom Brady would have wished for this, but last time New England had to circle the wagons, and we had a little issue called Spygate. The Patriots went 16-0, and then our good friends, the Dolphins, were able to pop their champagne cork when the Patriots lost in the Super Bowl. So New England is always looked at from a different perspective, and unfortunately, it's probably warranted with the kind of stuff that has occurred under the Belichick regime. He is definitely always looking to gain a mental edge here, and I still find it hard to believe, going back to the Wells report, that he got off clean, because I don't think anybody hiccups on the New England Patriots, and Belichick doesn't know about it. So in terms of what's happened here, it's a complete vindication of Brady. From the Patriots' perspective, it's a little bit ironic now that Bob Kraft paid that $1 million fine and gave up 2 draft picks. So I think there's going to be some grumbling about that, and as of right now, the Krafts don't appear to want to contest that. And my last point is that, I think the NFL should just call it a day. When you're 0-6 and you get overturned, and especially overturned in the venue that you chose in New York City that you thought was going to affirm your ruling, I think it's time to give it up and get on with the football season. And I guess there's a good reason why Roger Goodell will not be in Foxborough on Thursday night.
Well, as to the Patriots, we need to emphasize that Judge Berman's ruling did not touch upon guilt or innocence or whether it was done or whether it was not done. He only reviewed the process by which Tom Brady was disciplined, and that's what he found lacking. So the New England could very easily, in my mind, conceivably accede to
the suspension or the penalty, rather, that they were assessed because of deflated footballs. But when it comes to Tom Brady and his involvement, it's pretty clear from both the Wells report and Judge Berman's ruling, at least at this point, there's no direct evidence of his involvement. We have the famous phrase, more probable than not. Unfortunately, every first-year lawyer knows that's a meaningless phrase in a court of law, and as we should note, in an arbitration proceeding where there's a fair process doctrine. But, Jay, what I wanted to focus on was really the court's legal rulings, because I thought this case would always be interpreted under the basic standard of a long-standing labor relations trilogy of cases called the Steelworkers Trilogy, and that deals with the arbitral process in union management relations. My father was a labor arbitrator for 35 years, so I've been around this kind of work for a long time. And there's a well-known phrase called law of the shop. And law of the shop is the common law that arbitrators use to decide arbitration cases between labor and management. That can be a discharge case, someone gets fired. It can be a work rules case. It can be a safety case. But there's a law of the shop, and there are cases written up by arbitrators that get printed and bound up in volumes that create a law of the shop precedent. So there's a well-developed, you can't say it's law because it's not legal, but it's precedent and authority in the labor relations world. And those are some of the concepts that I saw Judge Berman find at fault with the NFL's process, and specifically with the commish, Roger Goodell, the rulings he made. I think probably the biggest issue was when you're in the labor relations context, union and management, you have an impartial umpire. You either have both sides selecting an arbitrator, or you have both sides striking 6 each so that the one left standing, odd man out, is the arbitrator. And they're truly viewed as impartial. You cannot say Roger Goodell was impartial in this in any way, shape, or form. He directed the investigation, the Wells report, by the NFL's law firm, and then his general counsel actually edited the report, which was used as the basis for the discipline. So you have the general counsel of the NFL editing an alleged independent report that becomes the basis for discipline. In the hearing itself, Tom Brady was not allowed to challenge those edits, to see the unedited versions, to talk to the general counsel of the NFL under oath about the edits that he made. And that was one of the things the judge talked about as the process not being fair. But there were some other specific deficiencies the court found in the process, one of which was the notice of discipline and misconduct. At one point, Brady was disciplined for a written policy which was distributed to NFL executives and applied to NFL executives. Well, Tom Brady's a collective bargaining unit member. He's just a regular working stiff, very well off working stiff, very glamorous working stiff, but under the contract, he's subject to whatever they say in the contract and whatever's delivered pursuant to the contract in terms of a written policy, a written conduct, code of conduct, and those sorts of things. And so he was disciplined under a policy that arguably didn't apply to him, but certainly had not been given to him. So he had no notice of the alleged conduct that he was supposed to have violated. The suspension itself of 4 games. Here, the judge just skewered the commissioner for comparing, for the purposes of discipline, Brady's conduct with the conduct of a first-time user of the performance enhancement drug policy, steroids. Goodell clearly in his suspension letter tied Brady's 4-game suspension to that being the same suspension given to someone who violated the steroid policy, and the court found no basis for tying a alleged violation of equipment use to something like a steroid policy. The next fault or failure the court found was that there was no notice of any discernible infraction. So this goes back to the more probable than not, I think, statement in the original Wells report before it was edited by the NFL. So there's no affirmative statement or finding that Tom Brady either directed or even indirectly caused the balls to be deflated. And I think the last thing that the court found at fault from a legal procedure basis was that it appeared Brady's suspension was dominated in large part because of an alleged failure to cooperate with the investigation. And this was thrown under the general penumbrum of conduct detrimental to the league. Well, once again, there was no notice to Brady. There was no notice that he could be suspended for failure to cooperate. He was alleged to have destroyed or ordered the destruction of his cell phone with text messages. And the court pointed out that the only other instance of a sanction being delivered against a player for failure to cooperate was a fine of $50,000 against Brett Favre for failure to cooperate in a sexual harassment investigation. And here we had a suspension of 4 games with an effective loss of salary of up to $1 million. So the court was very critical of basically charging Brady with post-incident conduct. And I think anyone who's taken labor law, anyone who's taken arbitration 101 knows that the discipline delivered to an employee has to be based upon the act. And it's not based upon what happened after the act. It's based on the act in question. And here the act in question was the deflating or alleged deflating of the balls for you homers out there. So the court really skewered the NFL and Roger Goodell from a legal perspective. You're absolutely right. Goodell is now 0-6. This was as strong a judicial slapdown as you're likely to see. Certainly it's even stronger than Paul Tagliabue's in Bountygate. So, unfortunately, we cannot grant your wish, Jay, that the NFL would just say, let's play ball, because they've already filed a notice of appeal. And I can't imagine that a court of appeals would overturn this, because I think, based on my knowledge of labor law, the court is directly in the mainstream of review of an arbitration award under labor law. And then the other point that I cannot emphasize too much is, in labor law, the reason you give such deference to an arbitrator is they are an impartial umpire. Roger Goodell has shown he is anything but impartial. And even if the contract allows Goodell to act as the arbitrator, the reason arbitration awards are given such deference is you have an impartial umpire, and that's not present in this case. So that's sort of my take from the legal side of things. But now we wanted to see if we might be able to tie it to some compliance topics. So Jay, let me throw out a couple of things, and then maybe get your thoughts, or if you want to take it in a little bit different direction. But for me, there's 2 things that I think are critical lessons for the compliance practitioner. And this is true whether they're anti-bribery corruption compliance or trade compliance, OFAC compliance, AML sanctions compliance. But it's 2 things. Number 1, the fair process doctrine is absolutely paramount. Your process has to be fair. And by that I mean, obviously, your disciplinary process. If someone did something, did they know they shouldn't have done it, and did you investigate it fairly, and did you review those facts before coming to a decision? Did you give that person the opportunity to state their case with or without representation, and then put a second set of eyes on it? So was the process fair? And the reason the fair process doctrine is so important is, in any situation, if people believe the process is fair, they're willing to accept something that they may not like. But if the process is fair, they feel like at least they got a fair shot. And part of the fair process doctrine is people get treated the same. That goes back to the disciplining Brady for an equipment violation based upon a steroid policy violation. That is not similar conduct, and the discipline should not be similar. And Brady's discipline should not be based on it. Brady's discipline should be based on other acts of or alleged acts of fiddling with the equipment, whether that be the footballs, whether that be yardsticks, whether that be sound pumped into a stadium, the equipment. And so that's what the commissioner should have looked to for a suspension or a fine or a penalty, and that's what you need to look to in your compliance program. To even tie it further, I think that means if you have people in South America that you fire for cheating on their expense accounts, and your top salesman in America cheats on his expense accounts, you got to fire him too. You can't let people off in one part of the world and fire them in another part of the world and have any credibility in your program. And the same is true of severity of punishments. So the fair process doctrine is absolutely critical in your compliance program. And then another way to look at it, which I think is equally important, Jay, is that fair notice has to be given. And the court was very critical that Tom Brady had not been given any written notice or any other notice that the conduct he engaged in would violate any league rule. In the compliance world, our policies and procedures start with our code of conduct. That's the guideline and guidepost for every employee's conduct going forward in a business. You implement your code of conduct through your policies and your procedures. That's how you give employees notice of the expectations of them. Here we had no notice given to Brady. And that points out a very important reason to have a code of conduct and policies and procedures, because you're setting expectations. Certainly it starts with tone at the top, but you get the message to people and make it personally applicable to them through your code of conduct and the policies and procedures. So those are my two sort of takeaways for the compliance practitioners. What do you see from your Homer side of the fence, Jay?
From the Homer side for the FCPA takeaways, I would agree with both those points that you made, Tom. And, I think even in a larger level, there really can no longer be any excuses for not knowing, whether you are a publicly traded company or you are a private or closely held company and you're doing business globally. Ignorance can no longer be an excuse, that you need to understand, as you said, that not only do you need the policies and procedures, but you need that one document, the code of conduct, to set expectations. And, whether or not there is culpability on the ball boy, the locker room attendant, and the guy who plugs the Uggs, it doesn't matter, because they did not have any notice, as you said, to what they were doing would, they knew it would be an equipment violation, but anything else that was kind of drawn in through the, kind of a dash of this, a bit of that ruling that, Goodell put together and then, made Troy Vincent enforce. So, realistically, coming back to it all, it really does underscore the importance for setting expectations, not only from a player and a league's perspective, but from a business and employee, and very importantly, a business and a third-party rep. And those are the things that, as you said, there needs to be equal footing, that if your top earner in the U.S. does something tricky with a T&E report, he or she should face the same consequences of somebody spending too much on a red envelope in Shanghai.
And we could probably add safely from both of our perspectives that those communications need to be in a form that employees can understand. So if you've got an international workforce, you better translate your code of conduct into a local language and train people on that code of conduct so that those expectations are not only set but understood by your employee base. And while you're doing your training, you also ought to think about, how do I assess whether they do understand it? Am I doing any testing? Am I doing any follow-up? Am I sending out any messages? Am I doing any annual training? Am I doing any semi-annual training? Am I sending the chief compliance officer or compliance practitioner just to talk about on a brown bag lunch compliance? So all of those things, I think, can be certainly read into the Berman ruling on the Brady suspension. Once again, I find the world of sports is a huge source of lessons learned for the compliance practitioner. Jay, I can feel your palpable joy at the start of football season with the golden one at the helm once again of the New England Patriots. So any final thoughts for the fans out there?
Just for everyone to enjoy the upcoming seasons, both the college season that started yesterday and the pro season that will start next Thursday. And have any of your teams gone out yet? I think Big Blue already had a bit of a stumble.
Yep. The Harbaugh era started off, I think my favorite tweet was, if the season continues like this, Harbaugh's head will literally explode on the sideline. So tough start for Brother Jim at University of Michigan, but we've got several big games this weekend and looking forward. Jay, I forgot to ask, but if somebody wanted to follow up with you as the VP of Translations at Merrill Brink, how would they do so?
Sure. 2 ways. By phone, 310-729-6746, or by email, jay.rosen@merrillcorp, which is spelled MERRILLCORP.com. And as always, Tom, great to talk to you about football, ethics, and compliance. And we'll give one more plug before this is over. Look forward to seeing you in Las Vegas at the beginning of October at the SCCE Compliance and Ethics Institute. And hopefully we can meet with some of our podcast listeners and discuss these ideas and the realities of how sports inform ethics and compliance at the Sunday evening tailgate party in Las Vegas.
Okay, well, thanks a lot, Jay.
Take care, Tom. Bye-bye.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have 2 calls to action for you. If you haven't signed up for my FCPA Masterclass, it's not too late. It is September 10th and 11th here in Houston, and it's sponsored by Merrill Brink. Please give me a shout at tfox@tfoxlaw.com if you'd like more information. Also, please go to iTunes and rate this podcast. I would greatly appreciate it. This is Tom Fox, and I look forward to visiting with you next week when we continue our series with Maurice Gilbert on hiring in the compliance space. Thank you for listening.